Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard.
Okay, folks, good afternoon. Welcome to the Appellate Division First Department. This is an honor for me. This is my first time as PJ, so we're going to, JP, and then we're going to try to get through this calendar. You know the drill for those of folks who have been here. If those have not, please ask for the time that you need to argue your case. We've read your briefs, we've read your arguments. We're fully aware of what's going on. So that said, let's go. Oh, I got to read the case. See, there we go. Something new. People versus Darrell Spencer. Okay, so let's do 5 and 3 and 4. Davis versus Angeletti. Okay, no rebuttal, you said? We'll do 5 and 5, thank you. M. Children. That's submitted. People versus Aaron Velez. That's submitted. Astor Ben Sasha LLC versus HFZ 235. 8 minutes. All right, I'll give you 7 and 3 and 6. Hoffman versus AKT in motion. 5 and 2. 7. All right, I'll give you 5 and 2 and 5. TID versus Ortiz. That's submitted. People versus Joseph B. That's submitted. Oh, on a roll. 116 Street Laundromat versus 240-42 West 116. Two. Give you 5 and 4 and 4. Thank you. Number 10, Integron National versus Joe. There's no appellant. You're the respondent. You care to submit? Yeah. Okay, thank you. We'll submit that. Okay, number 11, Lucky 195 Madison versus Creef 109. 7 and 3, you want it?
Respondent 6, Your Honor.
All right, we'll give you 5 and 3 and 5. Thank you. It's not your first go-around up here, I don't think, on this case, right? No, okay, all right. A lot, yes. All right, number 12, People versus Charles Patterson. Submitted. 13, Metrosorvic versus Best Market. Oh, you by yourself. Do you care to submit? 3 minutes? Okay, 3 minutes. Number 14, Mendoza versus Cornell University. That's a submit. BHBH versus 3 of Us Corp. 5 and 2. Okay, 5 and 2 and 3. Thank you. And the last case is non-enumerated. It's Kind Operations versus UAU Private, and that's submitted. Thank you. First case on the calendar, People versus Darrell Spencer. Painless.
Good afternoon, Your Honor. Stephen Strather from the Office of the Appellate Defender on behalf of Darrell Spencer. Your Honors, Darrell Spencer's conviction should be vacated or reversed for two reasons. First, because the conviction was against the weight of the evidence, because there was a reasonable doubt as to who committed this crime. Secondarily, because counsel in this case committed ineffective assistance of counsel by conceding that the prosecution had proven a murder in the last moments of his summation to the jury. Turning first to the weight of the evidence claim, the evidence in this case established the following facts. It established that the alternative suspect, Dorena Willis, was in the apartment around the time, or probably at the time, that the victim died in this case, that Ms. Hazel died. She also, according to the express testimony of Detective Minnelli, the lead detective on the case, she fabricated a motive for Mr. Spencer to commit this crime. She told the police that Mr. Spencer said that Ms. Hazel was pregnant and that's why he killed her. It turns out that that was a complete lie, as admitted on the stand by Mr. Minnelli, or Detective Minnelli. He also admitted that she lied repeatedly throughout the interrogation. Otherwise, the case has very few facts pointing to Mr. Spencer. In terms of forensics, it's pretty much equivocal.
Wasn't there a fingerprint?
There's a fingerprint on a shopping bag, which the testimony at trial establishes that, of course, could have been put there by shopping. It's a bag that was just in the apartment. That's it. There's also...
Didn't the defendant make a statement that, his second statement, that he in fact had killed the victim in self-defense?
Yes, he made a statement that he killed Ms. Hazel in self-defense, but that statement, two things about it. First, at the trial, Mr. Spencer explicitly, the counsel's position is, of course, that it's not, he disavows it. And there's a pretty good reason. It's because no one could have taken that statement as a good faith effort to actually make a real statement. It's so far away from the facts of the case that it really only makes sense as an attempt to kind of do the impossible, which is provide Mr. Spencer with an out, but also not get Mrs. Willis in trouble, because she's his girlfriend. And then if he wanted to get himself out of trouble, he knew she was in the precinct. He could have just blamed her. Instead, in his first statement, he doesn't mention her at all, even though she was there. In the second statement, he only mentions her to the extent that the police have told him that she was involved. In other words, he's trying to keep her out of trouble, but not get himself in trouble at the same time. Otherwise, the statement makes very little sense. Otherwise, the evidence in the case really doesn't point to Mr. Spencer or Miss Willis. It's kind of equivocal. There's no forensic evidence really tying either one of them to the crime in a meaningful way. And there's evidence that she was in the apartment as well and that she fabricated a motive for him to commit the crime. She lied to the police about it. We know she was involved. She admitted to that much. She helped move the body and she helped move clothes around the city. That she admits to.
He helped the defendant remove the body, the two of them.
Yes, no, Mr. Spencer certainly helped move the body as well. We're not saying Mr. Spencer wasn't involved or that he's not guilty of some crime like moving a body. What we're saying is that there is a reasonable doubt in this case as to who committed the crime based on the sort of minimal evidence pointing to Mr. Spencer and how it is equivocal with respect to both Mr. Spencer and Miss Willis. That's classic reasonable doubt.
Yeah, but his confession was before the jury, was it not?
The confession is before the jury. That's
Right,
correct.
so this is all, I mean, you're talking about weight of the evidence, and the jury had, on the cross-examination, whatever, all the evidence put before them, and they weighed all this evidence, so...
Well, your honors are empowered and indeed commanded by the Court of Appeals to do the same thing over again.
Only if it's, only if we believe it's against the weight of the evidence, though.
That's
right?
correct, and we believe it is because the reasonable doubt standard has to mean something, and in a case where there's very little evidence pointing to Mr. Spencer that also doesn't point to Mrs. Willis in the same way, we think that that is the definition of reasonable doubt.
Were the stab wounds?
I'm sorry.
Were the stab wounds that the victim sustained consistent with Mr. Spencer committing the crime or with Miss Willis committing the crime?
I actually think it's for both of them because the medical expert testifies that the first wound likely paralyzed her because at that point anyone could have done it. So it's really either one of them. Now, if I could say a couple of words about my ineffective assistance claim, because I think that's a very compelling claim. Counsel stood up, last couple of moments of his summation, and says, the intent of this person, the person who did this, was to kill. It was not to cause serious physical injury. Counsel believed this argument. He made it before, as in the motion to dismiss, to the jury, and in the 330-30 motion. It is a frivolous argument. If you intend to kill, you automatically intend to cause serious
Well,
physical
you don't
injury.
think that that argument was made to sort of avoid the manslaughter charge, or manslaughter conviction? Because I think in making that argument, he was pointing the finger at Hazel, correct?
So he is making an identity defense, an alternative identity defense, yes. But he's also basically ruining it here in these last moments. Murder is the most serious crime in the entire penal law. If you tell the jury the prosecution's proven it,
Counsel, there was no 440 motion here, right?
that's because there is no need for one. There's no way counsel could have had a legitimate strategy in telling the jury that the prosecution's proven the more serious offense.
How do we know that without a 440?
Because even if this court sat here and imagined reasons, none of them would ever be legitimate under the law.
You know, based on the arguments of the summations that counsel was making, he was trying to get an acquittal of the second-degree murder. It seems to me, I'm not saying that that's what he was trying to, it just seems like sounds like a strategic move on his part.
Well, the thing, second-degree murder wasn't a charge in this case, in this trial. The murder charge was out of the case after the first trial.
But he was making the argument, okay, I got it.
So if there are no further questions, I'll wait till rebuttal.
Hold on a second.
May it please the court, Noah Shamler for the people. I'm going to briefly clarify a few facts of the record, the first of which was my adversary mentioned that the medical testimony was the first wound paralyzed her. There was no such testimony. The medical testimony was there was a wound that was stabbed into the neck that ultimately was one of the things that may have paralyzed her, but that was one of over 31 stab wounds. There was no statement of any kind, nor could there be, as to in what pattern that took place. Furthermore, the statement that Ms. Willis fabricated a motive, the only statement in the entire record regarding this is the following testimony from Detective Manelli, which is, quote, Willis made those statements, and then she volunteered that those statements weren't true. That is the only comment in the entire record on this matter. To take from that the entirety of the defense on this appeal, which is that she somehow fabricated a motive and hid it from the police, is so many lines of inference and so far beyond speculation that it couldn't be considered. Ultimately, this is a beyond overwhelming case. You have a videotape confession that matches with the detective's testimony that establishes that the statement was voluntary. He said why he was giving the statement and why he was telling the truth, because his mother talked him into it. He said that in the video statement. He then provided a statement that did match up, except for the number of times that he stabbed her. And that is actually quite common. He doesn't want to fully accept what he's done. He knows what he did, but that's not an uncommon thing to not want to acknowledge that you stabbed someone more than 30 times.
So let me ask you, let me address the ineffective assistance counsel's claim where he said that the summation was towards a second-degree murder or murder, and what's your response to that?
Your Honor, my response to that, if you give me just one moment, I have to pull up the page.
The summation is on page 416.
No, it's directly quoted from my brief, Your Honor. This is the actual quote that's found nowhere in the defense papers. I mean, the people haven't even come close to proving that he's the person who did it. But even if somehow the people are able to prove beyond a reasonable doubt that defendant is the individual who did this, they still need to prove that the person who did this only intended to cause serious physical injury. He was not conceding anything. This was the 16th of 17 pages of summation. This is the end of summation when he came and said, for all these reasons, there's a third-party culpability defense and there's legal insufficiency. But even if you disagree with me on all of those, still don't find my client guilty, and here's why. And that is a perfectly viable defense.
Did he manifestly undercut all of his other principal defenses by making that point?
No, because he didn't concede his client did it. That's the emphasis of my adversary, is that he conceded something. He conceded nothing. He said, if you are going to find against me, don't do it for this additional reason, and it's a legal claim. Moreover, in an interesting twist, the prosecution missed it on their summation. They didn't notice even that he had made that argument, and the judge didn't give a special instruction allowing the jury to even consider this argument as a legitimate argument. My adversary spends much of his time talking about how, as a matter of law, it's not a proper argument. But that's not the question. The question on ineffective assistance is, as a matter of strategy, is it an argument that an attorney could give to a jury that they could reasonably accept? And in this case, it is, because there was nothing presented to counter that argument to the jury. If there are no further questions, I rely on my brief.
Thank you.
So on this ineffective assistance claim, I think we need to make something very clear. Of course, counsel can't stand up in front of a jury and make a legally frivolous argument and say, that's why that legally they must be acquitted. He says to them that the prosecution hasn't proven the legal part of their case. And it's true that he didn't concede identity, but think about it from the perspective of a lay juror standing there listening to counsel. The last thing he says to you is he says, okay, if you think that Mr. Spencer did it, it doesn't matter because he committed murder. Mr. Spencer's the only person sitting there. He's sitting right next to counsel. They're looking right at him. They're immediately going to turn around and walk back. They're going to walk back to the jury room a few minutes later, sit down and say to themselves, well, his lawyer said it's murder. That's worse than manslaughter. It's impossible to think that a lay jury wouldn't be swayed by a defense lawyer standing in front of them and saying, this case has been proven as something worse than what you're even asked to consider. Yes, that is going to undercut, and we cite this case from the Second Circuit that I want to point your honors to, Graham versus Smith. In that case, the evidence was overwhelming. The Second Circuit agreed with that, but they vacated a murder conviction on double jeopardy grounds, and they said, well, the evidence of manslaughter is overwhelming, and it's not affected by the double jeopardy problem, but we're vacating it anyways, because the stigma of murder is so powerful that we think it probably still tainted the manslaughter verdict. How is that not the case here when counsel inserts murder? Nobody else talked about murder in this case except for defense counsel.
What if defense counsel viewed his other defenses as particularly weak? And so this argument was, a potential lifeline for the defendant for an acquittal.
I don't think he thought about it that way. If he had it, he would have only made it to the jury. But he made it to the judge once before the jury, made it during summation, and then made it again in a 330-30 motion. This is a legally frivolous argument, and he's making it left and right. He believed it was true against all black 40, 50 cases saying that if you intend to kill, you automatically intend to cause serious physical injury. In other words, if he admits every element of murder to the jury besides identity, he's admitted to a greater crime. He's left the jury with very little to do, and he's prejudiced his client. That seems like classic ineffective assistance of counsel. And if that's the case, the conviction has to be reversed. So if there are no further questions, we urge your honors to either vacate and dismiss the indictment or to reverse the conviction. Thank you.
Thank you very much. Davis versus Angioletti.
Good afternoon. May it please the court, Rose Cotter, Vivaro, Cotter, and Bender for defendant appellants Black Diamond and 88 Greenwich. As the court is well aware, this is a fall from a loft ladder inside a condo unit. It was unit 1713 at a building located at 88 Greenwich Street. The condo was being rented by the plaintiff, Mr. Davis. It's relevant here at the timeline, which is crucial as to the ownership of the building, and I'll just go through that briefly. The building was owned by my client Black Diamond from 1999 to 2005. That was 9 years before plaintiff fell from a loft ladder.
So, counsel, one of the issues here, or some of the issues here that are presented are with respect to the ladder from which the plaintiff fell, or the injured party fell, excuse me.
The issue here is Judge DeGust denied
So the issue here, counsel, is one of the issues that I find, who designed the ladder, who installed it, and we don't have answers to that, right?
Exactly, and unfortunately—
And don't those create issues of fact that have to be determined by a jury?
They create issues, they create problems for the plaintiff's case. He has not named a party. Lend-Lease, who's a co-defendant in the case, it's
We do
clear
have
that
the
they
letter
did.
from July 1999 in which Mr., I don't know how to say the name, R-A-V-N, Raven,
Raven,
mentions loft rails and ladders. And he says, I don't remember. I don't remember very much, and this was a conceptual estimate, not an actual invoice or
Right.
an
Mr.
agreement.
Raven confirmed that at some point Lend-Lease did work in the building. He does not know if the loft ladders were part of that work.
So don't we need discovery here for starters?
Well, I don't represent Lend-Lease. Lend-Lease is still, in dispute with plaintiff, and that was part of my argument, especially in reply.
You represent Black Diamond, right?
Black Diamond owned the building in 1999 to 2005, 9 years before.
Right, and this letter was
the
written in 1999. So it's not really a question as to Lend-Lease, it's a question as to what happened back then, isn't it?
It's not an issue of fact because it's not clear who installed the loft ladders, when they were installed, and there's testimony from Lend-Lease in the record that says that it would have been an independent contractor who they cannot identify. They don't have all the papers.
Well, it's not enough for you to get summary judgment to point to putative gaps in the non-moving party's proof, right? So you
Yes.
have to make an affirmative showing of entitlement to judgment, a matter of law. So what evidence did you submit that demonstrated affirmatively that you did not create or cause this allegedly hazardous condition?
Well, we submitted the timeline that we had been out of possession of the unit, and Angioletti had owned the unit for many, many years, 5 years after 88 Greenwich was there, and 9 years after Black Diamond was there. And even if Black Diamond and 88 Greenwich wanted to get into the unit, they didn't have control over it anymore. So there's this huge time gap. And then it was clear, not evidence that I submitted, but the testimony of Lend-Lease, who would have been the contractor had the loft ladders been put in during our tenure.
But we don't know, we don't have any answers in this record, right? So we know that as a general rule that the liability of the property owner is deemed to cease once possession and control of the property is are transferred. But there's an exception if the former landlord affirmatively created the defective condition.
Yes.
Isn't that the whole issue here? Who created the defective condition?
I don't believe so. Judge DeGust got it right in saying that my clients owed plaintiff no legal duty because they had been out of possession of the unit for so long, and the co-defendant, who's already been let out, Angioletti, had been in possession. But the judge erred in finding an issue of fact as to affirmative creation of the condition because there wasn't an exception. It wasn't shown that there was any inherent defect. It wasn't shown that my client had control and did any work or design on the loft ladder. And Angioletti, the condo unit owner who rented out to the plaintiff, had possession 3 to 4 years prior to the accident. So there's these huge gaps. Anything could have happened to that loft ladder when Angioletti had sole possession of it. It could have broken.
Going back to my original question then, it's not, this isn't, we're not in federal court where a defendant can point to gaps in the non-moving party plaintiff's evidence and obtain summary judgment. You've got to make an affirmative showing. So I don't think you get there by pointing to the absence of evidence. You need to demonstrate through evidence that you submitted in admissible form that you are not liable. And so I guess that, in this case, that would take the form of evidence that we did not install this ladder.
Well, the record is clear that we didn't install it. If anyone installed it, it was a subcontractor of Lend-Lease who cannot be identified. So it was an independent contractor, and that independent contractor has not been sued, unfortunately, for plaintiff respondent. And my last point would be that to the extent the respondent relied upon discovery that wasn't given, that was a fight and still continues to be a fight between Lend-Lease and plaintiff. Black Diamond has not even been in business for almost 20 years, and 88 Greenwich close to it. For any other issues, I rely on my papers. Thank you.
Thank you.
May it please the court, my name is Elizabeth Luxembourg, and the issue before the court on this appeal is whether summary judgment was properly denied, given that factual issues exist as to whether defendants participated in affirmatively constructing a major property defect and launched an instrument of harm, in addition to the fact that new discovery has recently been unshed, something that defendants were put on notice of in our opposition motion. While you're right to say that the general rule is that prior owners are not responsible for injuries that occur on property that they no longer own, the exception to the rule is when prior owners affirmatively create a defect or launch an instrument of harm. This came out of the Espinal versus Melville Snow Contractors case, as well as Marrero versus Marsico and Mahar versus City of Albany. The defendants try to argue that they have no duty now because independent contractors were hired to do the work. That's irrelevant. Defendants can still be liable alongside independent contractors for affirmatively creating a property defect and launching an instrument of harm. The case law on this is clear. In Bartles versus Eek, Calderon versus 88-16 North Boulevard, Utica Mutual Insurance versus Brooklyn Navy Yard, Middleton versus Duval, and Mahar versus City of Albany. In all of those cases, the courts continuously denied summary judgment to defendants, prior owners, regardless of how long ago they owned property, where they failed to definitively prove that they had no involvement or participation in the creation of injurious property defects.
Do we know who installed this ladder?
We don't know who installed this ladder, and everybody that was deposed on the issue had strange responses to what was part of the construction, and no one had any knowledge as to the installation specifically of the loft ladder in issue. There's an absence of records, building plans, paperwork, and anything from these independent contractors that defendants try to cite now, which is something we mentioned in our opposition motion. In Black Diamond's case, they said they have no records whatsoever that would reveal who the tenants of Unit 1713 were from 2001 to 2005, no records of the work that was performed during the $42 million conversion of the property, no knowledge about the conversion, had never been to the building, was one of the
lack
people.
of these documents, then, it sounds like then you're going to be, the theory is going to be the res ipsa situation, right? I mean, if they don't have the documents, nobody knows who did it. I mean, at this point, then that's going to be the I guess, the theory that you're going to pursue in terms of trying to satisfy your negligence claim, right? That this staircase wouldn't have collapsed if it was, installed properly, correct?
Sure.
Right.
Res ipsa is definitely an issue, but that's really the breach portion. We feel certain that a duty was breached. I think the question right now for the court is whether there was a duty, and defendants are trying to say that there wasn't, but of course the timeline doesn't matter, because if they affirmatively created a property defect, they still owe a duty, and I think it's up for a jury to make the determination as to who created the defect.
Counsel, on this record, you heard your adversary point out that there was no evidence of a defect in the ladder, but you had expert testimony or expert affidavits, which basically talks about a cause and created, or a contribution to the loft, and the manner in which the steps were placed on the sides of the ladder that made it an accident to happen, although it didn't happen.
Yes, the defect is not in dispute at all, and that's why the breach portion of negligence is also not in dispute. It's just the duty question right now.
Right.
There are no further questions. I rest on my papers.
Thank you.
Thank you.
Astor Ben Sasha LLC versus HFZ 235.
May it please the court, Gary Mennett for the appellants. Plaintiff's primary claim against my client, the Astor fee owner, is an agency claim. There are also claims for breach of implied covenant, breach of fiduciary duty, constructive trust, and declaratory judgment, but those claims have no base out agency. So this appeal comes down to whether plaintiff has adequately pled agency, and they have not. And the complaint should have been dismissed in the lower court. As this court held in 1230 Park Associates, apparent authority must be based on words or conduct of the principal communicated to a third party, that would be the plaintiff here, that give rise to an appearance and belief that the agent possesses authority to enter into a transaction. An agent cannot, through his own acts, cloak himself with apparent authority. The motion papers make crystal clear that the owner, appellant, my client here, did not give actual authority and never did anything to indicate that anyone else had authority to act as its agent. Obviously, the defendants have scoured the record for any indication that the owner did or said anything about agency, and they have not identified a single thing. Why is that? Because the structure
I'm sorry, counsel, help me a second. So Mr. Zeldman was the signatory for both HFC owner and HFC portfolio manager, right?
That's correct, Your Honor. He would have been authorized, and if he had purported to bind the owner.
And what was his relationship to each of those?
He was the sole owner at the top level, and then the others were.
What are you calling the top?
That would be
HFC owner?
the holding company. No, not the owner.
The top, okay.
Yes.
So, and the money was given to the portfolio, right? HFC portfolio.
That's correct, Your Honor.
And it was intended for HFC's owner, right?
Well, the way that it worked, and the original agreements from 2014 are in the record I'm looking at the signature page,
No,
which
just
is,
enlighten me. You don't,
I got a flow chart here
Yeah.
that shows me that Feldman and Muir, HFZ Capital Group LLC is owned by Feldman and Muir, or at least they're related, they had some dealings with them, right?
that's correct.
There's also another arrow that says that HFZ defendant portfolio. I draw another arrow, it goes to Feldman and Muir also. And you tell me that arrow is good, right?
Yes.
And I got a third arrow that says HFZ owner defendant. There's another arrow that goes to Feldman and Muir. And then what we have here is then it gets really complicated. HFZ Capital Group LLC is owned by HFZ owner, and that, where was my arrow? And then HFZ portfolio is 16% owners, HFZ owner, and the HFZ portfolio is owned by HFZ Capital Group LLC. But all these arrows, funny, they all end up in the same place with Feldman and Muir.
Well, no, that's correct, Your Honor, but that doesn't mean that he was acting, just because a single individual has multiple entities doesn't mean that every time he agrees for entity A to do something, that he's also binding all of his other entities.
talking about $6 million.
No, I understand that, but with
And we're
this,
talking about these transactions that have these arrows, unless you're telling me my arrows are all pointing in the wrong direction, seems to suggest maybe there may be enough here to get past the 32 pre-answer motion to dismiss, right? Well, this is a pre-answer motion to dismiss, not summary judgment, right?
no, that is true,
But
Your
when
Honor.
you're talking about your clients, Feldman and Muir, having, well, he does one thing, doesn't mean he's gonna bind the other folks or doesn't have authority to do, I don't know. I mean,
Well-
it'd be interesting to see what he has to say at an EBT.
Well, Your Honor, that will be interesting to see.
Does he have an affidavit in the record here? I didn't see an affidavit.
He does not, but he is no longer affiliated in any way with.
Okay, at the
owner.
time of the transactions that went down, it would have been nice to see an affidavit from him, right?
Well,
Suppose, okay.
what we have in the record, I think is very clear that he was not acting for the owner. So we have, if you look at page 205 of the record, this is back in 2014, right? This is the manager, portfolio manager, selling shares in the holding company to the plaintiff.
Right.
And they sign, and it says acceptance of agreement to be filled out only by the manager. That's the only entity that was bound to sell those shares. Then there was an LLC agreement, which is also in the record, it's the next document, where there's a limited liability company agreement. Again, the owner is not a party to that. What was supposed to happen.
When you say owner, you're talking about defendant HFZ owner, right?
Yes, yes, that's correct.
Because you use, HFZ is thrown around so many times, that you gotta figure out who's who, right? Who's on
Well,
first?
the plaintiff here was an attorney. He knew full well that he did not have a binding contract.
Maybe he didn't draw the arrows as well as I did, I don't know.
Well, I think he did, Your Honor. And that's indicated in the record over and over again. Every single agreement, the first letter agreement from June 9th of 2014, which is the same day that he buys the interest at the top level in Portfolio Holdings, that's in the record at 22. The second one is in the record at 63. The third one is in the record at 67. And then the 2 pages that I just referred to for where he buys the membership interest, that's at 205, and the LLC holdings at 255. Again and again and again, he signs these agreements with other affiliates, and what they're basically saying is, you're buying interests in this top-level holding company. We know that you want to buy this apartment. When it comes time for you to buy the apartment, you're going to have a separate contract with the owner, and we will make a distribution from the holding company. We'll let you sell your shares, and then you can use that money to pay for the apartment. But the only contract that he ever signs with my client, the owner, is finally at the end, and that contract says, and they're represented separately by Kramer Levin, that contract specifically says you have to pay us cash. We're not giving you a credit for any of the, and he signs it. He agrees to that.
Thank you, you have rebuttal time, thank you.
Thank you, Your Honor.
May it please the court, excuse me, Harris Kogan of Blank Rome for the respondent. The record is clear.
I don't know, I think they're insulated themselves. I mean, from what I've gathered, he's saying that every entity insulated itself from any liability here, that, you know, there's no agency, and what your guy did was, you know, suing the wrong people, basically.
No, let's look at the contracts. As an example, you have the HFZ portfolio giving notice of the closing dates under the agreements. You have HFZ portfolio authorizing entry pre-closing into the apartment to perform $2 million of renovations. How did they get into that apartment? The owner obviously was aware of the agreement, obviously authorized access, and obviously authorized and ratified the conduct and the agreement that was signed by Mr. Zielfeldman on this side and Mr. Zielfeldman on that side. You know, usually when you have a case of agency and a question of agency, you have a rogue agent and the principal says, I didn't know him. I didn't know what was going on. Zielfeldman signed each and every one agreement. The letter agreements that are an issue here specifically refer to the unit purchase agreement, specifically recite obligations under the unit purchase agreement, and specifically say that in the event of a conflict between the unit purchase agreement and the letter agreement controls. On a motion to dismiss.
Sounds like we're dealing with one person, unless he's having an out-of-body experience, right?
Well, he was dealing with one person.
Right.
He was dealing with Mr. Feldman and had reason to believe that Mr. Feldman, when he signed something with the signature of portfolio manager, stating facts concerning the unit purchase agreement, that he had the right to rely upon that.
And if I'm wrong, correct me if I'm wrong, but did portfolio also own 16% of the owner?
I have to look at the chart that I prepared, but I believe that is the case.
Yeah, okay.
Yeah, I believe that is the case. There's
Yours
an
may not be
interrelation.
consistent with his.
So
But Mr. Feldman, was he entitled to or permitted to sign the documents in different or varying corporate capacities or for varying entities?
He was the principal, in essence, of each of those entities. He was the managing member or officer of each of the entities. If you see the signatures on each of the entities, his authorization is stated above it, you know, right next to his signature, what his role is in each of those entities. So yes, there's no issue here. You know, what's happened here, and let's...
You just want your money back.
Well,
or you want the apartment.
We want the apartment, we want the money, but what really happened here is that the mezzanine lender
They
who has
foreclosed on, yeah.
upon the interest, now comes in, succeeding to the rights of HFZ owner, meaning the rights and obligations, but says, I want the rights, I don't want the obligations. I gladly take in the apartment with $2 million of improvements that you did under the agreements that you had, but I'm not going to accept that the agreements that my client, that I foreclosed, my client, I'm not bound by them. You know, again, this is a motion to dismiss.
Yeah, and all those allegations are made out here, as I mentioned earlier, is that, you know, during the discovery process, if Mr. Feldman believes or is able to prove or demonstrate that he didn't, that there is no agency, I mean, that's something that's down the road.
That's down the road. But all of those issues, whether there was an agency, whether the documents are interrelated, these are all issues of fact that can't be resolved on a motion to dismiss. The issues of the relationship, the issues of unjust enrichment, the issues of the CIM defendants coming in foreclosing and then saying, thank you very much for the $2 million of improvements. Each and every one of those is an issue of fact at the very least. But we surely have survived the pleading stage in demonstrating that there is a potential viable agency here. I think it's pretty strong. And that the activities of both the HFZ owner and HFZ portfolio were interrelated, authorized, and therefore the unit purchase agreement has to be read with the letter agreements. The letter agreements specifically control under the terms, and therefore the $6.2 million which was paid is an application to the purchase price in accordance with the terms of the letter agreements, and for them to say you don't have the apartment and you forfeit your $2 million, not only the $6.2 million, but the $2 million of improvements, we believe is simply, you know, incredible.
Sir, with respect to your unjust enrichment claim as against the SIM defendants, how do you get around Georgia Malone's requirement that there has to be what I'll call, just colloquially, a special relationship to support that claim?
What George Malone said is that there can't be an attenuated relationship. And in George Malone, there were two separate transactions where one party was seeking unjust enrichment based upon a separate transaction. Here we have the CIM group coming in, foreclosing upon the interest, and trying to exercise its rights, if we call it that, under the very unit purchase agreement. There is a direct relationship between CIM and Astor Ben Sasha LLC because they succeeded to the unit purchase agreement, and therefore unjust enrichment is proper here. There is no attenuation. There aren't separate transactions. There is one unitary transaction. If your honors have no further questions, I will rest. Thank you.
Thank you.
To respond to my learned colleague, the only agreement that the owner signed is in the record at pages 26 to 43. It's the only one. They haven't pointed to anything else that the owner signed. They don't contend, they don't say in their papers there's anything else that the owner agreed to do, and nothing, you haven't heard anything here today. That agreement on page 43 has a signature block that's different from every other signature block on every other agreement because now the owner is being bound. And this was the intent from the beginning. So this is 2019. They invested in 2014. Comes time in 2019, they want to buy the apartment. They go back to the entities that owe them the money and they say, okay, the time has come. You have to give us back our $6 million and we're going to use that now to buy the apartment. So now they have an agreement with the owner. What does that agreement say? And they sign this agreement represented by counsel. What does that agreement say? On the very first page, page 26 of the record, it says the check has to be made payable to the owner's attorney and the check for the deposit and the check for the main payment. It says, and to no one else. It says that in paragraph 3.2, which is on that very first page of the agreement. So the notion that we want to take on the assets of the owner and not the liabilities is completely false. We live with the liability, but the liability is that purchase agreement, and if they don't pay for the apartment, they can't have it. It doesn't make any sense. What they're saying makes no sense. They have only one agreement with the owner. They don't point to anything where we authorized anyone else to accept payment for us. This wouldn't just be an agent either, right? This would be an agent for payment of money. We told someone out that someone else could take payment for us. That does not exist. It's extremely high bar, and we cite the cases saying that it's a high bar, and they don't meet it. If I could just have one moment to address the Georgia Malone issue. As Judge Higgett pointed out, there's one claim, this unjust enrichment claim against CIM Group and CCO. They were the mezzanine lenders to the owner, so they loaned money to the owner. They had zero relationship to his client. Nothing, there's not a single document, nothing connecting them. And basically what he's saying is that these entities, because they loaned money to the owner and presumably they got paid interest on that loan to someone else, they benefited from this relationship, and therefore they're unjustly enriched in some way that they don't even explain what possible way they could be enriched. They're just lenders. And the court below simply didn't address that issue at all. Didn't mention it. It didn't even deny it, just didn't mention it at all.
All right, thank you.
Thank you very much.
Hoffman versus AKT in motion.
Good afternoon. May it please the court, my name is Craig Deitch. I'm here on behalf of the appellant AKT in motion on this matter. This case is regarding a wrongful termination allegedly brought by the plaintiff allegedly based on discrimination on a physical disability. We're here because the lower court applied the wrong standard when my client sought to have the matter arbitrated pursuant to the parties' employment agreement that they had entered
Why
into.
don't you address the 18-month delay in moving for the compelling of arbitration? Because here there was litigation practice, right? There were appearances, extensions, preliminary conferences, stipulations as to a discovery schedule, all during the course of 18 months. So what happened?
Sure. Let me address that. In this matter, first off, this occurred during the COVID-19 outbreak. So for a good period of time, the access to the courts was limited and completely cut off pursuant to what Judge Marks had ordered. Moreover, there was not extensive litigation.
That has nothing to do with my question, counsel. There was activity during the course of 18 months. So it's not as if there was no activity during the course of 18 months because the courts were shut down.
But Your Honor, I beg to just differ in this case because there was not activity. In fact, there was no discovery propounded by my client. There was no discovery responded to. There were no depositions held. The only thing that happened, there were talks to try to settle, but settlement is just the nature even before you come into any litigation whatsoever. That is not an incident of litigation, just trying to settle the case.
Counsel,
Yes.
you had an affirmative defense in the answer you did file.
Yes, I did.
Okay, but that should have been an immediate motion made, but you engaged in some way, you engaged in a preliminary conference, true? Yes.
There was a preliminary conference.
And you engaged in agreeing to a discovery schedule, even though it didn't work back and forth. You agreed to that, which meant under the aegis of the Supreme Court part, you were litigating, true?
I would beg to differ that, again, the thing is we did not engage the court in action of turning the gears of litigation in this matter. This is very similar in some ways to a case known as Niesman versus Mount Sinai West where this court upheld the lower court's ruling that where the defendant in that case had placed an affirmative defense saying that it was going to, of arbitration, it put the plaintiff on notice of its intention. And in that case, the defendant actually propounded discovery upon the plaintiff. There was no depositions held, but in this case, we didn't even there was no discovery even propounded upon the plaintiff in this matter whatsoever. And again, while we're looking at the 18 months, I can understand that there was limited opportunity to go bring this motion in that time frame.
Well, no, as my colleague pointed out, you filed your answer on October 21, 2019. It's arguably 4 months before the pandemic hits. I mean, so, you know, I mean, that's a big deal. And then in the meantime, you know, things happen, right?
That's true, but again, in this matter, there was nothing else that occurred here. Again, where there was no affirmative use of any of the discovery in the court, and most of the case law always seems to turn, even where there has been an extensively longer time.
Here's my problem, counsel.
Sure.
What you're basically saying is that you can spin everybody's wheels and then at the last minute, put your finger up in the air and say, oh, it's time to do my motion to compel arbitration. I mean, you want to go through the dates, we can do that. The actions commenced in August of 2019, and in October, 2 months later, you ask for an extension. You get an answer, you get an extension, you file your answer, and when the preliminary conference is set up in November, you don't show up. But then in January, you show up and you don't say, I have a motion to compel arbitration. You accord a discovery schedule, and the plaintiff serves its demands, but you don't serve your demands, you don't serve a response. And then how many months later, 9 months after that, in October of 2020, you negotiate another discovery schedule. And then there's negotiations for settlement, which ultimately failed, okay. And then in March is when you wake up and smell the coffee and say, oh, time to do the motion to compel arbitration. What does that mean to you? You're saying that there's no prejudice to anybody.
There's no prejudice to the plaintiff in this matter at that time, again, because there was nothing that was done in the interim during that whole time. There was no discovery that was being engaged in. There was no discovery that was going back and forth with the parties. There was no motion practice going on even that time to compel discovery otherwise.
Okay, thank you.
Good afternoon, Your Honors. Anthony Concilio for the plaintiff respondent. May it please the court, this is a very important appeal because the employer, the appellant, is asking for the most stark and favorable ruling possible for employers at a time when New York's government, as well as other state governments and even the federal government, is sending very clear legislative signals that the pendulum has swung too far.
Well, but sir, we have to apply the law as it stands today, right? Not what developments may occur as likely as developments may be on the horizon. We have to apply the law as we take it today.
Understood.
So under Cusimano, we've got to balance three factors, right? The length of the delay, the amount of litigation that occurred, and I believe the touchstone factor is prejudice. And so how are you prejudiced by this 18-month delay?
Your Honor, the plaintiff is prejudiced because the plaintiff is prevented from moving forward with the claims and getting justice for 18 months, working the lawyers for the plaintiff. That is prejudice. The delay of justice is itself the prejudice.
Is prejudice really the nature of how you're going to get justice? Because arbitration is a very different environment and doesn't have the same rules.
Absolutely, Your Honor.
And there was a change even in our law that discrimination cases shouldn't be arbitrated, correct? I know it's prospective.
Well, a plaintiff should have access to a jury of his or her peers unless he or she has willingly and knowingly given up that right. Here, I think the trial court is in the best position to make determinations about what the activities during discovery mean, and the appellant is essentially asking you to do a de novo review. I hope that you'll articulate the correct standard of review in your decision. I think that the trial court has to make a rational determination supported by evidence. But the facts that the appellant is asking you to consider are very telling. As your questions highlighted, the employer gave no explanation for its conduct for those 18 months of discovery to the plaintiff, to the trial court, or to this court. The employer has touted the fact that it pled this affirmative defense as if that somehow helps it. We have to assume that the attorney who signed that pleading investigated and asked, did you have your employees sign an arbitration agreement? Can you look for it and find it for me?
Well, if they hadn't pled the affirmative defense of arbitration, you obviously would have a much stronger position that there was a waiver, because not even the affirmative defense was asserted.
Well, that gets to the trial court's determination that the employer's silence during discovery was a meaningful activity. And that, I think, is the correct analysis that you should...
So the silence manifests the acceptance of the judicial forum.
Yes, and it's also using the judicial forum to toy with the plaintiff, to string the plaintiff along, to show up for a preliminary conference after missing a preliminary conference, to engage in a discovery schedule after ignoring it.
Well, the defendant's allowed to take defensive measures in the action, right? They're allowed to assert an answer. They can't default at the preliminary conference, because that would be a different form of a waiver and acceptance of the judicial forum. So they have to take certain, or are permitted to take certain, under DeSapio and Stark, they're allowed to take certain defensive actions in court. What they're not allowed to do is engage in conduct that manifests an affirmative acceptance of the judicial forum.
That's correct, Your Honor. And
so what did they do to manifest that affirmative acceptance of the judicial forum?
All of those activities. A pleading was signed with that affirmative defense. No one brought it to the plaintiff's attention, whether it actually existed or was just affirmative defense included formulaically. They came to that second preliminary conference after their absence was noted by the court. They engaged in that discovery schedule. Those are meaningful activities, exactly as the trial court said.
Okay, thank you, counsel.
Just a quick rebuttal. There was certainly, the agreement was attached, the employment was attached to the pleading. There is, and it was cited in the papers and also in the answer, where it is an arbitration clause that was signed within the employment agreement. As far as silence, I will go say there is nothing that ever said silence acts as acceptance. I understand the court that the 18 months is troubling. However, there was nothing that was any affirmative acceptance of the judicial forum, and I believe the case law requires that. There's no case law that says silence equals acceptance. In fact, it has to say that you have to clearly accept the judicial forum.
What do you call the two discovery schedules then that were accorded?
The discovery schedule that's...
means nothing.
I'm not saying, Your Honor, it means nothing, but again, it's compliance with discovery schedule. Again, it would be...
So you're saying that you can stipulate to a discovery schedule and then knowing that you're not going to comply?
No, that's not what I'm saying, Your Honor. What I'm saying is that it's the action of seeking discovery, looking to enforce the discovery schedule. Bringing motions is where you're engaging the court. And as far as being able to access justice and prejudice that comes out here, there is nothing that indicates that justice is swifter from the courts or swifter from arbitration. In fact, in some argument would be arbitration would be a quicker way to get justice. There's nothing that the plaintiff put forward of how they're actually prejudiced. Only thing they said is my client's prejudiced just because this is taking a long time. In that case, every action in the courts, we're all prejudiced because everything takes a long time.
You don't explain your delay, right?
Again, the delay, Your Honor, you made it clear that it was not, the 18 months I feel is misleading because the court access to it, even to make a motion, was unavailable for a good portion of that time. Even if I wanted to bring the motion, I couldn't do it. The court said no. In fact, we stayed cases for that reason. That cases were pushed back, that we were stayed. I thank you all, and again, for your time this afternoon.
116th Street Laundromat versus 240-42 West 116th.
Good afternoon, Your Honors. May it please the Court. Ira Matetsky from Ganford Shore Leeds and Zouder for the appellant. In this case, the motion court granted a mandatory injunction. It was called a preliminary injunction, but I'm not sure it was really preliminary to anything, which required the tenant to vacate the entire premises, which was a working laundromat into which it had invested over $1 million, for as much time, on 10 days' notice, for as much time as the landlord said was necessary. There's no dispute that
There's no vacate order for your client, right? The vacate order, the record indicates that all the residences above the commercial premises they're vacated. It's an empty building.
That's correct. Both HPD and the DOB directed that the second through the fifth floors, which are the residential premises, which we don't have access to.
And I guess your argument is, why are you having us vacate? If the DOB didn't tell us to vacate, why can't you work around us, right?
That's part of it. In fairness, I think it's a little more nuanced than that. The issue is whether there's a necessity for us to be out of the space for the landlord to perform this work.
I thought I said that, but okay.
Well,
You don't want to get out. They want you out while they're doing the work.
That's exactly right, Your Honor. What I was saying is, what the judge did not do is hold an evidentiary hearing or make factual findings that there was a need for us to get out, or for how long we needed to get out, or how much of the space we needed to get out. He took the landlord's and the landlord's engineer's conclusory reports word for it, that we need to be out.
It's interesting because I think in the record here, the Supreme Court thought that your experts were conclusory.
Well, if we don't agree. We think our experts went into significantly more detail than theirs did. But if that's the case, that's all the more reason why there should be some limited discovery and an evidentiary hearing to figure out who's right.
But counsel, at what cost? You do limited discovery. I mean, this is a situation where, and this is something why it was surprising, nothing in the record indicates that where are these residents or the tenants that have vacated? What's going on with them? Because, you know, we have a situation here, the multiple families that are out of their residences, and no one seems to care about them, because that would be something like, we need to move this as quickly as possible so we can get everybody back in. And there's nothing in the record that even, and my colleague pointed out, like, where's all this, where's everybody?
Well, that's not information. That may be a question that Your Honor respectfully may want to ask my adversary. We're a laundromat on the ground floor. We don't have that information.
Okay.
Our limited information is that these people have been rehoused some time ago. I mean, it's not like there was some urgent emergency that
Well,
this
when
work
you say well, I'll ask the question to the.
I sincerely don't know where these people are now.
Is there anything in the record that indicates which of the experts here actually inspected the buildings? Because when I looked at Mr. Yainblatt's affidavit, there was no indication that he inspected the residential portion of the building. It was only the commercial portion?
Unfortunately, that's correct, Your Honor, and that's because we had no access to the residential portion because
Let me switch it up 1 second, if you don't mind.
Please.
Is there any indication in the record that the engineer hired by the landlord, Mr. Smith, inspected the building? Because I didn't see it.
I didn't see a lot of evidence that, or any evidence that any of the engineers took a close look at what was going on in the residential space. Certainly, our engineers had no access. Had we been granted even a limited period of discovery, we would have requested that access and been able to determine.
So one of the determining factors would be what the findings were of HPD or DOB, right?
That's relevant, but HPD had no jurisdiction in HPD doesn't know what needs to be done in our space.
I know that.
Yes.
Thank you.
It seems like the argument that Supreme Court gave credence to was the landlord's argument that says that we couldn't do this massive restructuring of the residences with the commercial tenants in place because it'd be too dangerous. The liability would be enormous because we'd have these gigantic, it's literally shoring up the apartments and everything, and to have, them to operate their businesses would be a complete danger. We couldn't even get liability insurance for that kind of coverage, and I think Supreme Court accepted that, right? I mean, it sounds like that's where it went.
I think Supreme Court did accept that, and our submission is that that's an issue of fact that there should have been more fact-finding on. And if I can move a minute of my rebuttal time to here, I would point out that we know that's an issue of fact because the housing court, the landlord-tenant court, in a case involving the other downstairs tenant in the same building with the same engineer for the landlord and the same engineers for the tenant, found that there was an issue of fact. We quote this on page 16 of our reply brief, and we've given Your Honor the L&T court decision, which we ask you to take judicial notice of. They found that there's an issue of fact. There was no emergency here that should have pretermitted the ability to hold the 6312 hearing. The work still has not been done. The building permits still haven't been obtained. They're still in litigation with this other tenant. We had 7 months since this order was...
I want to ask you a different question, if may I? So I believe that in your brief, you state that the beams in the building are all wood and there's no steel involved, but in looking at the diagrams, I do see that there's a portion that refers to replacement with steel beams. So part of the owner's argument here is that by installing steel beams, the possibility of danger to the floors below is created because a steel beam could go through a floor and ostensibly go through the building. Is there anything in the record, one way or the other, as to this issue other than this hypothesis?
I don't think so. I think what you find in the record is that there are references to wooden joists, there are some references to steel beams, but one thing that we're not told is whether the installation of this, why specifically the installation of the steel beams on the upper floors creates a risk to the tenants downstairs, nor are we told for how long of the 2-year estimated duration of the construction, and there's no schedule, there's no chart, there's no timetable. I don't know how long it takes to install the steel beams. Assuming arguendo that the steel beams are an issue, maybe there's a week when the steel beams are going to be installed. That doesn't justify, with no fact-finding, an injunction that we have to be out of the entire premises for as long as the landlord says so, which they tell us might be 2 years or more. If there's going to be any injunction here, it should be after a hearing, it should be limited, it should be tied to the specific period of time where there's a need for us to be out, and there should be some sort of independent professional making that determination and not the landlord say so.
Okay, thank you.
May it please the court, Henry Masha for defendant respondent, Housing Development Fund Corporation. Supreme Court struck the right balance here.
So where are the tenants? It's not in the record, but do you know where they are? I mean, are they going to come back?
They have been relocated, but they are ready to come back once the apartments are finished.
So okay, this is not a situation where you're going to have new tenants. The tenants that had been there will be coming back.
That's my understanding. That's correct.
So my next question to you is, we have a situation here where Supreme Court was very receptive to the argument that we cannot do this gut renovation with this laundromat in operation because the liability will be just untoward. How, as counsel pointed out, you haven't got even a building permit yet to even start construction project. right?
Well, there's a few reasons for that. The first one is that it's undisputed that we can't get insurance, or our contractor can't get insurance to do this. They didn't put anything in response to that. That's what our
That's not an
contractor
answer,
swore to.
counsel.
That's not the tenant's
Whose
fault.
fault is that?
No, meaning that the insurance will not be provided because it's too dangerous.
That has
Right,
nothing
but
to
whose
do with the
fault is-
permit. Sorry.
Well,
Whose fault is that the
Oh, easy,
building
guys.
is in such a condition that you can't get insurance?
no.
The undertaking
We
of the
can't get
project.
insurance while the commercial tenant is still in occupancy.
See, that's what I don't
And
understand.
the oth-
You know, I read this case and I read the record here. We have a situation where you need to gut renovate the floors above the commercial tenancy. You know, and I've seen construction projects come across my desk here that are so more complicated that these guys can do, that contractors and construction workers can do amazing things. But it probably, in all likelihood, will cost more money to do what you want to do to keep the commercial tenant in place.
Well,
To shut them down for 2 years straight,
Well,
you know,
there's a couple points there. First, they're not necessarily going to be shut down for a couple of years. Supreme Court specifically limited the preliminary injunction to require the landlord to minimize the impact to the tenant. And so the tenants have the remedy if they can vacate the.
Counsel, that is the most amorphous statement that you could possibly have made. I mean,
But it's still in
really.
the order. We still have to abide by
So
it.
let's talk about the timeline here.
Yeah.
Okay? The owner has had possession of this building since 1990, right?
Correct.
Okay. And if you look at the open violations issued by HPD, in one building, it's 198 violations, of which 62 are C violations, and in the other buildings, there's 189 violations, of which, how many? 93, I believe, are C violations. So we are in the year 2023, and the owner has had ownership for how many years? 33 years. One questions what the trajectory of maintenance in this building has been, right? I mean, that's not an untoward question.
It's a fair question, Your Honor, but the reality is that the landlord is suffering.
Then we go to the issue of the permit, and that's very troubling. How is it that you are talking about basically evicting a commercial tenant from a premises for a period of up to 2 years, when you haven't even gotten the permit?
Well, we have to give 10 days notice before they have to leave. So we have not gotten the permit yet, but they need to get out before we can even begin to do that work.
No, they don't.
We can get a permit
Counsel,
before.
they don't. You know that the
But we
permit
need
can
to-
be renewed. We're not ignorant here, counsel. We have experience with this. This is, you know better than that.
Your Honor, I think we need to take a step back here. The landlord in this case is a Housing Development Fund Corporation. That means its primary purpose is to provide affordable housing, and we can't do that unless we renovate the property.
Sir,
And
I
any
agree with
commercial-
what you just said, but in light of the timeline and the events that Judge Gonzalez just read out, how is the landlord's conduct vis-a-vis the maintenance of the residential aspects of this leasehold consistent with its underlying purpose?
Well, Your Honor, there is a whole host of legal and financial consequences that the landlord is suffering under to this day because of those repairs that need to be done. I mean, that's not something that this court needs to resolve in this appeal. I mean, there are consequences, and the landlord is going through them now. The point is that they need to get the property repaired and renovated so that the residential tenants can move in. And they also have to there is work that is being done to the commercial space. That's not something that should be lost. They also need to inspect the commercial space. The plaintiff's expert even admitted that there may be some conditions behind the finished walls that weren't visible. And we get access also to do visual inspections as well.
Sir, in considering the balancing of the equities element, should we be considering the diligence that the owner exercised or didn't exercise in maintaining those residential units?
No, I don't think that's a factor, because the main point here is that the building is going to continue to deteriorate, and the affordable housing will be unavailable to New Yorkers during that time.
I think that's a very convenient argument, counsel, if I may say so. with, if the owner has allowed this building to deteriorate during the course of 33 years of ownership, how can your client be relied upon? And I'm paraphrasing what my colleague is saying. How can your colleague be relied upon to complete a remediation of the violations and so on, without a time frame that is set by the court subsequent to an evidentiary hearing where the testimony of the experts is heard, is weighed, and then acted upon?
Well, it's our position that a hearing is not necessary, because there's no question that the landlord gets access to the premises based on the lease. The tenant could have negotiated a more favorable standard for the landlord to get access, but they didn't do it. So there's no question at all that we have established a likelihood of merits on our counterclaim for an injunction preventing the tenant from preventing the landlord to get access. That's what we need
Yeah, I
in
don't
order to
think
get
that,
the
I'm not so concerned about the access point, because I think it's well taken that, you do have that ability to get in there. We're all concerned about, at least from the questions here, is that this 2-year process of requiring or disrupting the commercial tenant's ability to conduct its business is a
And
little bit.
that's a fair concern, but I think Supreme Court, by limiting and requiring the landlord to minimize the impact to
Well, here's the
potential
It's a
tenant.
conclusory finding, because the court didn't hear how much time you really need to do what you need to do to keep the commercial tenant, which is your anchor tenant. It's an HDFC, which means you're counting on the laundromat to give you serious rental income, true? Because your basic rents, which are now
Sure.
$1, is it $1 or something like for all these tenants to preserve their right to come back?
I'm not sure.
Well, but you're not getting any income stream, right?
Right.
And you're probably going to borrow a boatload of money to have to do all this.
And there are other things happening. There are third parties in the
So
works.
this is the point. You have an anchor tenant that paying good rent, that put in $1 million into your property to increase its value as an HDFC building. So don't you think the court, rather than saying, okay, I unilaterally let you do it and you be the judge of this, no pun intended, maybe we need to understand how much time you really need with the battle of the experts to determine what exactly is needed. As my colleague pointed out, access isn't really the issue. It's the duration of that access.
That's a fair point, but I don't think that a hearing is the proper place for that. This is just a preliminary injunction. All of that can be hashed out in
Counsel,
the
there
court.
is no such thing as just a preliminary injunction. You know that.
Well, my point is that can be fleshed out during the course of the litigation. If
You know what I thought was
delay.
interesting when I was reading the record, when Supreme Court was hearing arguments from the attorneys, and he made a very pointed question to the landlord's counsel, saying, well, what are some of the abatements or some of the concessions that you're going to give to the tenant for the disruption? And it was kind of the answer was kind of like, there wasn't an answer. At the end of the day, well, we'll look into it. You know.
I mean, I can't speak to negotiations that are going on.
I know, I'm just
and
saying,
so-
but that factors in, I'm looking at this too, in terms of whether or not the equities, balancing the equities, because whether or not the tenant, the commercial tenant,
Right.
it's being unreasonable in its determination of not vacating, especially if the landlord comes in and says, are you kidding me? We've offered them X, Y, and Z, we told them X, Y, and Z, we've even done the abatement in terms of rental, and they're still not willing to vacate. That point, then, I think my colleagues here would say the equities may sort of tilt back in your favor. But when I read the record, the transcripts, I didn't read anything of that nature of, offer.
It's true that we have offered to relocate them, but the record is
How
not.
are you going to relocate the laundry machines? I mean, that was the point
record,
that I read.
I'll
It was
concede, Your Honor,
hysterical.
the record is not clear about the negotiations that were ongoing between the parties. That's a totally fair observation. I have no.
I'm just saying that what I've read in the transcript is what I have. That's all I have in front of me. And the bottom line is that for us to understand the equitable part of this, is that, I've seen situations where the commercial tenant is doing it on purpose. They refuse to do anything, just to stall the process.
Right.
But in this case here, I don't see that. I don't see evidence of that. It may be there, it may not be there, but the question was pointed right to the landlord. The first 2-3 questions the Supreme Court asked, and the answer was just,
The record does not have a lot on that topic. I'll concede that there's no way to get around it. I would just say on the balance of equities, the availability of the affordable housing is really the main concern.
Let's get right to the heart of it. The balancing of the equities, it's all about money, because at this point, as we all know, there's nobody upstairs. It's just a
Right.
commercial tenant. So the project is gonna cost more money for your client to get done, okay? That, I think we all can agree, it's got, the longer you're here and the longer we're here arguing this kind of
Absolutely.
case, the meter's running. as they say.
Absolutely. That's what the landlord and the tenant both have an interest in getting this done as fast as possible.
Well, I don't know about the commercial tenant, because he hasn't seen anything on the table yet. But
Well,
anyway, okay, I got it. We got it. Thank you. You didn't lose any rebuttal time.
I appreciate that, Your Honor. It's not about access. If they need to come and take a look at something, they can look at it.
As my colleague pointed
Of
out, it's the
course.
duration of the access and how much you're going to be disrupted in
Well,
terms of doing your
It's
business.
the duration, and there's a difference between access, saying the landlord can have access, and saying that we are out of the premises and cannot have access. Normally, an access case means somebody is coming and doing an inspection, or somebody is doing work in that corner, and we're operating the laundromat over here. They're not asking for access, they're asking for ouster for a long period of time.
Sir, how do you address your friend's point that there is a bit of a public policy twist to this case, and that is that it is low-income housing that is above your leasehold, and that you want to get that remedied and available to those who need it? How does that factor into the particular, I guess, the balancing of the equities element for the PI?
It might factor into the balancing of the equities if the landlord had in fact shown by the requisite quantum of proof that the only way to do this work safely is by completely forcing us out of the laundromat. If the judge found as a fact, based upon an evidentiary hearing, that the choices are either we vacate the space for not 2 years, but for some period of time, or the residential floors can never be repaired ever, that would go to the balancing of the equities, and we'd have a different case. I'm not conceding the outcome would be different from what I'm asking, but it would be a different case. We have this case in which there's been no evidentiary hearing, there's been no discovery, there is a conclusory expert report from the landlord saying we can't do this work unless you completely vacate indefinitely, and reports which we think go into significantly more detail from our professional engineers saying this work can be done safely upstairs with an appropriate protection plan, with us being out of the premises for no time or minimum time. The equities would be best served if the landlord did this work, as the judge suggested in precatory language, which is not part of the decretal paragraphs of the injunction, and which Your Honor pointed out is a little bit vague and amorphous, but the judge said, yes, it would be nice, it would be appropriate if the landlord did this work in an expedited manner as possible, and in a way that disturbs the tenant as minimally as possible. The equities would be balanced if the landlord put together a plan that said with specifics, we're going to be doing this work on this date, we're going to be doing this work on this date, either best case sat down with our experts, or worst case have an evidentiary hearing in front of the judge, as is going to be happening anyway in the other case. It's going to be happening anyway. It's not like it can't be done, it's being done. And then we could find out where we would have significantly more information about what's actually necessary here, and we could begin to balance the equities. The equities certainly don't
Counsel,
balance.
was any mediation ordered by the court?
The answer is that after Judge Cohen said, there was no mediation with a formal mediator that I'm aware of. What did happen is that after Judge Cohen said from the bench, in the transcript Judge Oing was referring to, that I'm inclined to enter an injunction, but I want to hear some more from the parties about the form of the injunction, and he gave the parties a 30-day period to work it out. And unfortunately, partly because of this lack of information about exactly what was going to be done, the parties were not able to work it out, and then he entered the injunction. And during that period, we asked to put in additional evidentiary proof. We implored the court to hold it up, to give us some discovery so we could inspect upstairs. We could have a hearing. The hearing would long be over by now. The hearing would long be over by now. And frankly, at this point, given that nothing is imminent, given that there's going to have to be a trial in the L&T case, frankly, I don't see any possible downside, any possible prejudice, even if the landlord hypothetically is totally right, to vacating this injunction, reopening the proceedings below, and let them prove they're right. I don't think they'll be able to do that, and I think there'll be a rebalancing of the equities based upon what the evidence actually shows.
Anything else? All right, thank you. Lucky 195 Madison versus Creef 109.
Good afternoon, Your Honors. My name is Philip Greenberg. I'm the attorney for the appellant third-party defendant, Stephen Sung. As you noted when they were calling the calendar, this is not the first time this case has come up before the appellate division, although the last time my client was not a party. However, when Creef was rebuffed by this court, they then turned around and filed the third-party complaint. The first cause of action was against the parties that actually had defrauded.
So, counsel, your client issued an opinion letter.
Yes.
Right, that Creef allegedly or argues and asserts that they relied on.
Right.
And your opinion letter that your client authored didn't have the usual, disclaimers. Why then should we dismiss this third-party action? I mean, usually, and I've seen opinion letters, they've got like a gazillion disclaimers on there that after a while, this disclaimer itself swallows up the entire opinion. Unless I read the wrong opinion letter, I didn't see any disclaimers.
It didn't have disclaimers, however, just like in the Fortress Credit Corp case, which was...
Fortress is a very different set of facts than here. By way of one example, in Fortress, the opinion letter makes clear that the attorneys are not verifying the authenticity of the signatures or any of the players in that. Whereas here, Mr. Sung made it very clear that he was authenticating the so-called conspirators on behalf of Lucky and Creep.
Well, the opinion letter here doesn't authenticate it. What it does is he says he's relying on these documents. It's undisputed that he had those documents. He relied on those documents, and...
But counsel, it's more than that, isn't it? The opinion letter says we have also examined the original or certified copies of the documents of formation relating to the creation and organization of borrower and such other certificates, documents, and opinions, and have made such other inquiries with respect to the borrower and the loan as we have deemed necessary or appropriate for the purpose of this opinion. And the letter opens by saying that Mr. Sung acted as counsel not only for Lucky, but also for the two alleged conspirators. It also says further on in the record at 96, the borrower and the guarantor have the right, power, and authority to execute and deliver, and has duly authorized, executed, and delivered each of the loan documents. That's not based on reliance. That's based on actual examination of the docs.
I agree, and there's no allegation here that he didn't actually look at those documents. And I must respectfully disagree. That's exactly what happened in the Fortress case. While with or without disclaimers, what was clear in both the Sung opinion letter and the Fortress case is that they were relying on the documents that they reviewed. And also, as I explained...
But counsel, in Fortress, the attorney who signed the opinion letter expressly stated that he assumed the genuineness of all signatures and the authenticity of the documents. He made no independent inquiry and he undertook no independent investigation of the facts. Here, you have a different circumstance.
Well, if you look at the Sung opinion letter, he does
I
not.
beg your pardon?
If you look at the Sung opinion letter, which is at issue here, he does not say anywhere in the letter that he made an independent inquiry.
Well, an examination of the originals is an inquiry, isn't it?
Yes, it is. And there's no dispute that he did examine all of the documents that he listed there.
And have made such other inquiries as we have deemed necessary or appropriate.
Yes, but it doesn't specify what that
Fortress didn't say that. Fortress is not a parallel.
Well, except that as with Fortress, there was no guarantee, there was no undertaking of a separate investigation, and that he was relying on the documents. And moreover, as we explain in our brief, if anything, what they're alleging here is that Mr. Sung was negligent in his issuing the opinion letter. And in fact, if you look at the two causes of action that they allege, one labeled negligence, one labels fraud, the negligence claim on its face was time barred, as was mentioned in the footnotes and in the answering brief. On re-argument, Justice Hagler granted that aspect, which is why we took that. We're not arguing that here. But as
Counsel, isn't your main claim that the plaintiff, Kreef, did not do due diligence as a matter of law? And in fact, that's how you interpret the earlier 81 decision that I think my learned colleague was on that panel.
Thanks
but I
for
didn't
pointing
read
that
it that way.
Yeah, I wasn't 81, but yes. That is definitely one of our strong arguments, because what this appellate division did in that previous case is they reversed the granting of dismissal to Kreef and said that there was no indication here that Kreef did the necessary due diligence. And then Kreef moved to re-argue before this court, of course, and said, oh, well, we didn't have to do that. The court overlooked the fact that we had the Sung opinion letter. And this court said, the Sung opinion letter doesn't get you off the hook. You still have to do your due diligence. And it was at that point, after this court unanimously reversed them, that they started to look around for others to sue. And
That re-argument decision said that?
No.
no, what your decision said was that
Re-argument is denied.
It's denied.
I mean, officially,
One word.
one line,
One line.
5 words. It didn't say all that you just said.
right, but
You're speculating as to the mindset of the panel that denied the argument, which could be for a whole host of reasons.
well, except that the basis of the motion to re-argue was that they had the Sung opinion letter, and they said we could rely, we were entitled to rely on the Sung opinion letter, and therefore we didn't have to do due diligence. That was the basis of their motion to re-argue. Yes, I recognize that the court didn't write an opinion, it just denied it, but I'm just saying that was the basis of their motion to re-argue, was that the court had supposedly overlooked the fact that the Sung opinion letter let them off the hook from having to do due diligence.
Okay.
The only last, I see my time's up, I just want to point out also, as was amply argued, that under CPLR 1007, this is not a proper third-party complaint against Mr. Sung, because it does not seek similar or parallel relief, and that their only response to that was citing the George Cohn case of the Court of Appeals, where it did have some broad language, but it was exactly the same thing, where there's monetary in the main claim and monetary in the third party, and their fallback on that is, well, that we're relying on an antiquated interpretation. Well, maybe it's an antiquated interpretation, but that's the precedents that have established that if you're suing for money, you have to have been sued for money. And so that would be a additional separate grounds for reversing the lower court and dismissing the third-party complaint against Mr. Sung as a matter of law.
Thank you.
Thank you.
May it please the court,
Mark Berman of the law firm Ganfer, Shore, Leeds, and Zadra. Let me just begin with the 107,007 point that counsel just raised. I referred the panel to records pages 77, 78, and 81, where this specific issue was raised with Justice Hagler, and effectively the parties said, enough, we've waived it, we're going to move forward, we're not going to ask for severance, we're not going to ask dismissal, let's do what people do and litigate it together. So that really is a red herring, Your Honor, on this appeal. Justice Hagler made it very clear on page 77 of the record, and this is a 3211A motion. At this early stage of the litigation, I believe, given that we have the affidavits of support, and the other evidence in the record, there's certainly enough evidence here to go forward with fraud. There's at least the inferences that there are, and that's sufficient at this early stage. Mr. Maloney, you can make a motion for summary judgment after discovery is completed. Let's move on. We've had an hour argument before Justice Hagler once. We've had a 45-minute hour before Justice Hagler twice. We've had a re-argument motion before Justice Hagler on this issue, and counsel for Sung has moved again against an amended third-party complaint where we made a change on the assignment language, and they said, we've made a change in the assignment, we're going to do it all over again. So right now, there's a motion to dismiss the fraud claim before Judge Hagler, where our opposition papers are due next week. So this is the fourth time that Justice Hagler will have seen this fraud and has sustained it 3 times. I'd ask this court to affirm. We will be back here because after Justice Hagler denies the motion to dismiss the fraud claim, and we actually had the deposition of Mr. Sung 2 or 3 weeks ago. It's the horrors, the record, but it's terrific testimony that we will put in opposition saying, it's a new client, it was a referral. By the way, I never spoke with Tang. By the way, Steve-O, I don't recall. I never spoke with Chin. I don't know how I got the due diligence documents. I don't know where I got the due diligence documents. I don't know why I have the due diligence documents. That will be all part of the motion practice before Justice Hagler, which we, I guess, decided shortly. You got it right, Justice Shulman and Justice Gonzalez, on what this opinion says. I don't have to tell you how different Fortress is. They assumed the genuineness. They said, we're not looking into the documents. We're not verifying anything. That was really, here are the documents, we're writing an opinion. No carve-outs. No qualifying language in this opinion. And it says, as you said, Justice Gonzalez, and make further inquiries. Okay, so we have a fraud case. And how does this department in opinion letters deal with fraud? In Factors versus Candell, but even without the aid of discovery, the complaint identifies shortcoming in the audit procedure alleged to amount a reckless disregard of the true state of the financial conditions. It is one sounding in fraud in which a showing of gross negligence will permit the trier of fact to draw the inference that fraud was permitted. This court, in Remediation Capital, 147 AD 469, in a legal opinion letter, really makes it quite clear that you don't grant motions to dismiss on the basis of legal opinion letters where there is no caveat like this. In that case, like the plaintiffs in DGJ management, plaintiffs in this case made a significant effort, like my client, to protect itself against the possibility of falsehood. They found out in the loan documents they were a sham by obtaining a written opinion letter from Noto, the borrower's attorney. That's what lenders do. Lenders go to the borrower to get comfort. They don't know the borrower. And in this case, making at least one material misrepresentation that, based on the allegations of complaint, was inconsistent with the actual value of the property. We don't have a valuation here issue, but as in DGJ management, on a motion addressed to the sufficiency of the pleadings, It cannot be held as a matter of law that plaintiff required to do no more, and whether plaintiff was justified in relying. This is a motion to dismiss under 3211. Now, Your Honor, Justice Owing, you were on the panel way back when this came up before you, and the appellate division ruled in a certain way about due diligence. And Mr. Sung's counsel has latched on to that first department decision made on not a 3212, but made on a 3211 basis. And if you look at that decision, and it speaks to specifically, CREEF and due diligence, and saying, we're going to deny the motion to dismiss on a 3211 based on the allegations and insufficiency. And it says CREEF should have done more. CREEF did more. They got the opinion of Sung, who was supposed to verify and corroborate that these were legit borrowers. So when you look at what the first department did the last time, do more, they did. They relied, as all lawyers do, doing transactions, on the opinion of the borrower. Lenders don't know who the borrowers are. He was required, Mr. Sung, under the opinion, to look at the originals or certified copies, opinions, documents, and make further inquiries.
Okay. Thank you, counsel.
Thank you very much, Your Honor.
You got 3 minutes. Yeah, you got 3 minutes.
Yes.
Mr. Berman,
I don't think I'll
he's
need.
got 3 minutes to go.
Oh. Thank you. Well, first of all, on the CPLR 1007, this is the first time I hear in this case that it's referred to as a red herring. They don't meet the requirements to bring us the third-party complaint on the CPLR 1007. That's hardly a red herring. I was surprised that learned counsel made so much of the re-argument motion, which they lost. The court granted, after a very extensive argument, granted re-argument on the issue of negligence.
And so now it's crystallized. Now we're talking about fraud, right?
Now we're talking about fraud, but as we argued in our brief, and again, both sides, of course, especially opposing counsel, have made much of this, the or is the record part, but since it was raised, as we detailed in our reply paper, in our reply brief, the Justice Hagler did not take the next logical step, which was to dismiss the fraud case, because the fraud and the negligence essentially were the same allegations. So he should have taken the next logical step. But again, I'm surprised he makes so much of the re-argument motion, considering that a major part of his case was dismissed at that time.
But they do allege at paragraph 27 of the complaint that your client knowingly made false and misleading statements, which is clearly bespeaks of fraud, not negligence, and is in a different aspect of the complaint than the negligence cause of action.
Right, but he tries to, right, but they try to tie it to the actual fraudsters, which were the first cause of action, and they made much in their answering brief about the fact that Chin gave a confession of judgment, and that there was an admission of over half by the fraudsters/conspirators. However, it's clear on the papers, their papers, that Sung had nothing to do with the fraudsters. So they just made the conclusory allegation that Mr. Sung made a fraudulent statement. But all his opinion letter says, this is what I've read, this is my opinion, and there's no indication that he did an investigation. He did not say, I'm doing an investigation to go behind the statements to find out if they're accurate, which was, again, what happened in Fortress. And in terms of the Sung deposition, I acknowledge my co-counsel handled that deposition. I think it's completely inappropriate for him to bring it up, but since he did, I got a very detailed report, and all I can say, with all due respect to Mr. Berman, is that either my report is completely wrong or his report was completely wrong, or when he took the deposition, because from what the detailed report I got of Sung deposition, it sounds like he and
All right,
I
thank you,
spoke
and I'm
about
sure we will see it at some point. Thank you. Have a good
Thank you,
afternoon.
Your Honors, for your time and patience.
Thank you. Metrosovic versus Best Market. We responded, correct?
I'm, yeah, we're the
You're the appellant.
Yes, Best
Thank you.
Market.
Okay, thank you.
Good afternoon, Your Honor. Thank you, and may it please the court. My name is Christopher Conway. I'm an attorney. I'm here on behalf of Best Market and Iaconis and Fusco. Your Honor, we're appealing the denial of the summary judgment because we believe that that was wrong. We think that the facts in this case...
The door hit the person in the inspector in the head. The question is, how did the door, why did the door, how did the door hit her in the head, right? I mean,
Exactly, Your Honor, and we don't think that this really is an issue of fact to be determined at trial because we have evidence that on a prior inspection, and just to set the record straight, this is on a refrigeration unit, an ice machine that's 6 feet above the ground where the panel is, similar to the panels of air vents here in the court, and it was fully secured with a screw, and the evidence is that it opened from the bottom, hinged up to the top, so it's a bottom-up lift.
Yeah.
So on a previous inspection, the inspector had gone in there and she had inspected. She said that she had found some evidence of vermin
Right, so she came back a second time, right?
Exactly. She was not with her supervisor at the time. She was with the manager. And as they went over to the unit, the manager was there. He says that he saw her with a screwdriver interacting with the panel. And for a brief few moments, they turned away. They heard the panel fall. She says, ow, and he lends assistance.
I don't think, is that really what was in the record? Didn't Mr. Bustamante say that he believed that the plaintiff had a screwdriver with her? He didn't see her take out the screwdriver. She was pointing to the door and saying it needed to come off so she could see the motor. And then later on, he says something different, which is that she had the screwdriver in her hand, and it happened right then and there when she unscrewed it. So we have two different versions from the same person, don't we?
Well, no, Your Honor, I think that he's very consistent. He says as soon as she came in, that she had tools with her, that she accessed a screwdriver. And I think that the only question here is, was he looking when she specifically put the screwdriver up against the screw? And I don't think that he did see that.
But in her deposition, she denies having a screwdriver.
Correct, Your Honor, but I think that logic tells us that if the air vent is secured by a screw and without any intervention by anybody, it cannot fall. It cannot become unscrewed and fall. And since she was there specifically to interact with that specific air vent and to look inside the motor, I think that the evidence is pretty clear. She was there.
Counsel, logic tells me that what you're saying is speculation. We don't know.
Well, it's not speculation, Your Honor, not speculation at all. It is known that vent was secure prior to the inspector going over to it, that it was secure by a maintenance person on a previous occasion that was testified by Mr. Bustamante, that it is only accessed when a technician comes. And on this occasion, when the inspector came, she went specifically to that space. Now, if she says that she didn't touch it, Your Honor, I think the logic tells us it does not fall on its own. It fell because she went to take a look at it, and in a brief moment, it hit her. It's not our fault. And, Your Honor, I'd just like to make, before my time runs out, the question here is...
Your time ran out, but I'll give you the point.
Thank you, Your Honor. The question is, did we create a dangerous condition, and did we have notice of that? Obviously not. This is an ice machine 6 feet above, so we did not create the situation. Did the store have an opportunity to prevent the situation from happening? And the answer is no. This is not a slip. This is not a slip and fall where there's a puddle. And finally, we contend that the plaintiff created the situation herself. that without her intervention, without her going over there and touching the panel, but for that, it would not have fallen upon her, and that there was no notice to us that we should have been doing something different with the panel. It's a piece of machinery that is inaccessible by normal means, and that we believe that the evidence says that the denial of the summary judgment motion was inappropriate. We ask you to grant summary judgment.
Okay, fair
Thank
enough.
you.
Thank you.
Thank you, Your Honor. Thank you very much. Have a good day.
BHBH versus Three of Us Corp. Last but not least.
May it please the court. My name is Brian Morrissey on behalf of BHBH. This too is an appeal from a 3211 decision, and there are no affidavits in this case. Procedurally, since January of 22, when this case was commenced, we've been apprised that the guarantor, Mr. Palmer, received a discharge in the New Jersey Bankruptcy Court without notice to the landlord.
Okay, so this at the bottom, my understanding is you have a guarantee from the individual who got a discharge, right? And that there was some sort of agreement that that individual had with defendant Nasberg?
Nasberg.
Right? And that you're arguing that defendant Nasberg is a guarantor also, right?
Before I make that argument, I admit we don't have the 5705-701 explicit agreement. And the issue comes up as to whether there was a substitution or an assignment.
Right.
We think under those latter two categories, it's appropriate for us to be able to conduct discovery because the facts that have been drawn out during the pendency of this matter include the bankruptcy, but also include the disclosure of the term sheet. And in that term sheet, there's obligations undertaken, and whether we are the beneficiary of that is open to discovery. Nasberg subsequently bought the company, and that's when the rent payments stopped. Nasberg is the central focus here. To borrow from an earlier appeal, all arrows point to Nasberg.
So, counsel, what about the language in the term sheet that it's not intended to be a definitive or exhaustive list of all business and legal terms, and then goes on to say that material terms and provisions shall be incorporated into a definitive written agreement? Doesn't that pose big problems for your argument?
It doesn't make it easier, that's for sure, but it warrants discovery, I believe, because as we see in the record, there's an attorney who sends in the finalization documents that are supposed to occur subsequent to the execution of that term sheet, the selling of the company. And so when Nasberg finally buys the company, there's a closing process.
Right, but look, he buys the company, no question here. He buys the company, and based on what we have in front of us is that he's going to indemnify the guarantor. He's going to indemnify Palmer, who got a discharge in bankruptcy. So the way, right, is that what happened here?
That is what's happened here.
So that the way I read this is that, you know, he's only an indemnitor, right? He's not really a guarantor. He's the backup. Once you proceed, from what I'm reading here, reading the documents, is once you proceed against, if you prevail against Palmer and Palmer doesn't make good on the guarantee, then you can turn to Nasbeth to indemnify that. He's the indemnitor under this situation.
And in that vein, Your Honor, I would argue that he still belongs in the lawsuit.
But not as a guarantor. You're looking at...
No, not as a guarantor, but that's what's changed during the pendency of this lawsuit is our position. The facts that have come to light only as a result of the commencement of this lawsuit go back years and warrant discovery. And in those documents, and at this point I would refer to this court's Mandel decision, where they say that if you are that decision says that if you are lacking the explicit agreement, and an appropriate assignment can be seen from the facts other than my client's consent to the substitution or the assignments. In other words, if there was a closing document that we haven't seen yet that says that Nasberg was assigned or was going to do something more than the simple indemnity obligation, that's what we need in discovery. And there's...
I'm sorry, counsel, I'm confused. didn't you are principally going after Nasberg in this lawsuit below, or if it were still alive, as a guarantor, you want to get a judgment and have him satisfy that judgment. That's my understanding of the legal theory that you used here. And that's why the court dismissed it, because there was no written guarantee, correct? I don't know your theory of assignment. I mean, putting aside whether Palmer needed permission from you to get an assignment, which, I mean, I'm not going there right now. I mean, I don't hear or see the word assignment here. This whole case was all about the guarantee.
That's how it was pled, because at the time we commenced the action, that was the understanding. Since then, it's been averred. We've seen the representations that there's, and we did, if there was an explicit substitution of guarantors, of course my client would have seen it. But looking at the assignment, that comes directly from the Mandel case that my opponent quoted in their brief. And in that case, from this court, it allows for factual discovery to find out whether there are facts.
So that I'm trying to understand, sir. You're basically saying, I started this action against Mr. Nasberg as the guarantor, even though you weren't part of that term sheet agreement at all. And now I want discovery to be able to determine whether there's been an assignment.
Or
is that which is a totally different theory, a different theory. There's no amended complaint. Was an amended complaint filed here to change that theory from a guarantor to an assignee to be responsible for stepping in the shoes that way?
Mr. Nasberg was not a party to the case when the action was commenced. He was added in the course of the amended complaint. And in that amended complaint was the pleading as to guarantor, that he stepped in the shoes of Mr. Palmer.
But that's exactly what Justice Shulman was saying. You made, not to get, you're lacking something here that we don't have in front of us with your arguments, right? In terms of your
What we're lacking is
new theory of your case here. We can only go with the theory that's in front of us right now. This new theory, I mean, you're saying that there's some new developments that happened since this case was pending before us. An appeal, right, with Palmer going into bankruptcy.
I am saying that.
So that, I mean, your theory may have changed, but we're stuck with the theory that you started with.
I think that the nature of the breach of contract claim that we've asserted throughout translates to this, or incorporates this instant situation as well.
Whether you're saying what instant situation? This instant situation?
That we have a situation where our two people, Palmer and Nasberg, schemed to get rid of Palmer's obligation.
Is that in your complaint that we have in front of us?
No, but what I would...
Counsel, let me just jump in a second. So you do have a reference to the discharge order, right? Mr. Palmer's discharge order?
Yes, we have that in the record.
And that was from 2019?
We didn't learn about the discharge until 6 months ago, or whenever the New Jersey attorney wrote it to us. We were not given notice. We were not a listed creditor. We were a $2 million, we were...
You found out April 1st, 2022?
It's in the record.
Yes. I'm reading a date from the record.
Okay, yes.
Yeah, but the whole, okay, I got it. Thank you. You have rebuttal time. Thank you.
May it please the court, Corey Gray from Greenberg Traurig for the respondent. Your Honor.
You can see why we're struggling here, right? Because he's coming up with, I think he's coming up with a theory that's not pleaded in the complaint here.
I think that's exactly what counsel's doing. I think it's a non-cognizable theory, however, Justice.
That's not for us to say, I mean, right? But
no, I think that's right. It is not currently before this court, to be sure. I don't know of any situation, I do a lot of lender work, I don't know of any situation where a lender can be asked to take a new guarantor without its prior consent. Not, oh, you switched guarantors on me, I'm okay with that later, which is essentially what is being argued by BHBH here. They're saying, let us take discovery, because we may find that Mr. Nasberg agreed with Mr. Palmer that he would become a guarantor. Even if he agreed to do that, it didn't happen. BHBH can't be forced to accept a substitute guarantor without acknowledging it and without accepting it. It's in fact, I know I only asked for 3 minutes. They go quicker than I expected.
Don't worry.
But it isn't.
There's nobody in back of you. You don't got anybody breathing down your back.
But it's been a long afternoon for your honors as well. I will be succinct. The guarantee itself says it can't be waived or modified unless specifically set forth in writing executed by the landlord. That's in the guarantee itself. So if that certainly would include a release, that would be a modification. That would include an assignment, that would be a release or a modification. Under the guarantee itself that BHBH seeks to impose upon Mr. Nasberg, it could not have been the case that Mr. Nasberg and Mr. Palmer privately agreed without BHBH's consent that Mr. Nasberg would step into Mr. Palmer's shoes. I want to make one, because I know you're very familiar with what is hopefully probably the smallest record you have today. I want to make one point about the public policy ramifications of this. If BHBH were correct that guarantors could privately agree to substitute liability one for the other and the lenders can't have the prior say-so to that, you can only imagine what that would do in the financial institution world in particular.
Or on the flip side, if we were to agree with the plaintiff here that they could go after anybody they want, and say, you're the guarantor now. And I'm like, how am I the guarantor? I mean, the flip side is, I think the flip side is even worse.
Justice, I was going to say exactly that point. I just think
that will let any lender, if you just happen to be in the room, to turn around and say, guess what? You're now the guarantor.
Yes, Your Honor, that's exactly right. And I just wanted to make the policy point. I'm sure you've all thought of it already. And the factual record is reasonably clear. The law simply doesn't support what BHBH seeks, and we would ask the court to affirm the trial court's dismissal.
Thank you.
Thank you, Your Honors.
This is not a case that is opening the floodgates to baseless claims. Mr. Nasberg came in without our notice and told the person who owes us money that you can stop paying rent and I'll take care of you. Why don't you then go to bankruptcy court so you don't have to pay the rent and then I can walk away with the business for $1?
Counselor, it appears on its face to be a really ugly situation. I will concede that to you, but you're not alleging any wrongdoing like fraud or anything like that here, right?
We haven't really had that opportunity, Your Honor.
That's what we have. We're stuck with what you have in front of us right now.
And my best answer to that is that a broad breach of contract claim can incorporate a business tort, can incorporate the other claims that were...
But you're asking us to fill in the blanks for you. We can't do that, right?
I'm asking for the continuation of this lawsuit so that we can amend the complaint if the facts warrant. Right now, we asserted facts that we had a good faith basis to assert. We've been told of other things during the pendency of a motion to dismiss. We couldn't change the pleadings.
So could you change them now?
Right now, Mr. Nasberg's not in the case, but if we asserted new claims and brought them back in the case, I'm sure they would put some objection to that.
I've seen enough, you know, attorneys, they're very creative in terms of pleading. So, you know,
I'm a little confused. You kept saying breach of contract. Did you say that term before?
That's the title on the cause of
No.
action.
I just want to make
I
sure
did say
I'm hearing
that,
you
sure.
accurately. So, but right now, there's no privity of contract between BHBH and Mr. Nasberg. There is privity of contract. There was a lease with Palmer and his entity, and Palmer defaulted in paying rent as your tenant, and you have an outstanding arrears against him for all this rent, all fair. That's a breach of contract, privity between you and Palmer. But there's no privity of contract between you and Nasberg. Yes or no?
No, we are a beneficiary, though, of their agreement.
okay.
Okay.
Okay, thank you.
I'm sorry?
Does it ever get old working in this room? It's spectacular.
Always beautiful.
Oh, my God. Isn't it? Have a good one.
You too, thank you.